Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of these government documents, baby. We are back again, May 23rd. A law passed by Congress, House Joint Resolution 61, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Environmental Protection Agency relating to national emission standards for hazardous air pollutants in the rubber tire manufacturing process. All right. Once again, Congress putting on its nullification hat here, this time for a rule issued by the Environmental Protection Agency, EPA, concerning hazardous air pollutant emissions from rubber tire manufacturing. Kind of an interesting little niche thing here. Very cool. So on November 29th, 2024, the EPA finalized amendments to the National Emission Standards for Hazardous Air Pollutants, otherwise known as NESHAP, for the rubber tire manufacturing industry. This was in response to a 2020 court case, Louisiana Environmental Action Network v. the EPA, which mandated the EPA to regulate previously unaddressed hazardous air pollutant emissions from rubber processing subcategory within the industry. So, the finalized rule aimed to reduce emissions of total hydrocarbons and filterable particulate matter by approximately 171 tons annually. To achieve this, the rule required facilities to implement certain emission control technologies like regenerative thermal oxidizers to meet those new standards. And just as an explanation of those thermal oxidizers, very interesting technology. Basically, they heat up the air hot enough to where pollutants are just eviscerated. They're destroyed. Very interesting. And then it actually takes that heat and reprocess. That's another story. But so as a result of this new law passed by Congress, that rule is no longer in effect, legally speaking, null and void. And the agency is barred from issuing a substantially similar rule without new legislation authorization. That's one thing I don't know if I've really impressed upon you all as the audience. When it comes to the Congressional Review Act, if Congress nullifies a federal agency rule using that power, that agency cannot create a substantially similar rule without legislation going through Congress. So basically a bill would have to pass the House and Senate saying that the rule can come back. So very, very key there. All right, that's it for this one. Kaimo, keep your mind open, do your own research, form your own opinion. Bye-bye.